law whatsoever indicating that terms of probation or conditions of sentencing have ever been considered a disability. Obviously, there's a distinguishing factor between terms of sentencing, which subjects somebody to resentencing, but doesn't subject them to new criminal charges, typically, and a conviction or some other type of ineligibility that's contained in Article 265 of the penal law. And I cited practice commentaries that tried to decipher what that meant, and they didn't come to a conclusion that would suggest that conditions of sentencing would be included. And the only case law I could find on the topic, People versus Charlin, went into an analysis related to federal law and what is prohibited by 18 U.S. Code Section 922, and are never included in that list. So what we have is a unprecedented theory of prosecution that does not appear to be supported by any case law anywhere, though I note that there is a significant amount of ambiguity in the term disability because it was not defined. And so I think that's the first issue the court has to decide on. If the court decides that conditions of sentencing would be required too broad of an interpretation of the term, then the analysis ends there, and the sole count of the indictment should be dismissed. If, however, the court determines disability is so broadly defined that it can contain any type of ineligibility that is remotely related to any legal proceeding whatsoever, then the analysis or the issues sort of split off at that point, and we have both the next legal insufficiency issue as well as the constitutional issue. So to focus on the legal sufficiency issues momentarily, the court referenced what I think is fine at this point, which is those terms and conditions of probation, even if a condition of probation could be a disability, those are noxious substance. We've been litigating this case for some time, and
yeah, I think you both would agree. I'm sorry to interrupt you. We're talking about dangerous.
Yes. To the people's credit, they acknowledge firearm does not include the term shotgun, and that's been something sort of disputed in the past, but that's been resolved by the Bill of Particulars, as we cited in the Court of Appeals case, included in our materials, in multiple Court of Appeals case. The terms dangerous weapon and dangerous instrument have been used interchangeably by the courts. That's, even if there's no statutory definition, in at least one of the Court of Appeals case, they specifically say, contrary to the prosecutor's argument in that particular case, dangerous weapon and dangerous instrument included a specific definition for dangerous weapon. In any event, if the court were to find that the terms dangerous weapon and dangerous instrument had maintained some sort of different meaning, despite the case law to the contrary, dangerous weapon would definitely be a more restrictive term than dangerous instrument. They have the same modifying adjective, but one is a general instrument, which would obviously be more encompassing than a weapon. And essentially, the people are arguing, well, dangerous weapon should be considered have a different meaning in this case, and it should actually be interpreted broader to include unloaded guns, despite the fact that the case law and the law in New York has been abundantly clear that unloaded guns are not dangerous weapons or deadly weapons, and by effect not illegal in that respect in a case like this, at least not unless there's some evidence of unlawful intent, like the gun was going to be used as a bat or a bludgeon. And obviously that doesn't exist in this case, and that's clear from the grand jury minutes that the gun was only held in a very innocuous manner for a very brief period of time. So I think that issue is abundantly clear. What the prosecution asks the court to do is find a new definition of dangerous weapon that has never been provided anywhere. It was not provided in the conditions of probation. It was not provided by the sentencing judge at the time of sentencing. It was not provided any time since that sentencing date. And the reason that that's particularly significant is because, as the court knows, there was a violation of probation filed, litigated, and ultimately withdrawn. And during the course of those proceedings, nobody involved, the judge, Judge Aronson, who sat as the sentencing judge in this case and originally issued the terms of probation, or the prosecutor, ever said that there was a misinterpretation here and dangerous weapon should have included an unloaded shotgun. Nobody's ever made that assertion at any time whatsoever. So the first time that's really being asserted is in terms of the charges against Ms. Astacio here. And what that basically requires somebody to do is speculate as to what this different meaning of dangerous weapon is, and speculate that it should have included an unloaded shotgun. And even if the court were to find that there's a different meaning for dangerous weapon, and that could include an unloaded shotgun, there is nothing, no evidence whatsoever that would have suggested that Ms. Astacio would have been on notice of that separate meaning. And that's where we come into the mens rea issue, which is, let's say that, although completely speculative, Judge Aronson meant that term, dangerous weapon, to include an unloaded shotgun. There's no way that Ms. Astacio could have speculated herself that that was the intention. All she could do is rely on historical case law and historical definitions of the term dangerous weapon, and certainly draw the conclusion that that does not include an unloaded gun unless it's being used in a different manner and in a manner that has unlawful intent. So, you know, when we get to the point where we say, okay, there's some argument here over to what the term dangerous weapon could have potentially meant in terms of probation, the analysis I don't think has to go that far, because ultimately, if there was no other definition set forth for Ms. Astacio anywhere in the record, or there's no evidence of that, then on the mens rea element alone, the court should ultimately dismiss this. And finally, I know that this has been discussed at length, and I don't intend to go too much further on it, but there is the issue of attempt, and it's a fourth issue, and each of these are individual issues. Each of them are individual bases to dismiss.
Dangerously close.
Obviously, the grand jury, the CJI jury instructions were cited by both the defense and the prosecution in our papers, and dangerously close is the term that's used. And you know what we noted, and I think there's just form 4473, which is an ATF form. And after they fill out the form, a background check is conducted, and it's determined that the person is ineligible. They're denied purchase, and theoretically, in most cases, they'll walk out of the store having been denied a purchase, and that would be the end of it. And in this case, she never even got that far. She never even looked at form 4473. She never went through the process of filling out 4473, reviewing form 4473, which has 3.5 pages of instructions first. She never produced payment. There's no evidence that she even had payment on her. She simply expressed an interest in purchasing the shotgun and provided a driver's license, but she didn't go nearly as far as I believe other people have without ever having faced criminal charges. And in some respect, I think if I can almost confidently say, had somebody not called the police and had the Monroe County Sheriff not responded and issued a press release, there wouldn't have been any pressure for them to determine some form of charge to put on Ms. Astacio, and which they ultimately did 7 days later. I just don't think it would have ever went this far in most cases. This case is being treated completely unique from the way this situation would typically be handled. And that somewhat speaks to the constitutional issue in terms of arbitrary enforcement. Obviously, if the term disability is so broad as to include conditions of probation, our position is that the statute is unconstitutionally vague. It defies a defendant's right to due process to be put on notice of what the charges include. The fact that there's so much argument over what that term means and what's included within the statute, I think, is certainly supportive of that position. But that's one constitutional issue of 4. And I think really maybe the strongest issues are those related to how the Constitution, how Mrs. Astacio's constitutional rights were violated as the facts are applied to this particular case. And there were 2 issues there. Mr. Porsche did respond to them in sort of one encompassing paragraph. But the first is, and this is all related to her Second Amendment rights, is that if somebody is going to have their Second Amendment rights encroached on, if there's going to be a taking of a constitutional right, then there has to be due process afforded to the defendant. and for whatever reason, I did review a video of the sentencing proceeding where Mrs. Astacio was put on probation. It's online. For whatever reason, because of a number of things going on, there was never an opportunity to be heard on any objections to the conditions of probation. Mrs. Astacio wasn't provided with a copy of what the conditions were going to be. She didn't sign that document or review it in court, and she did not object. So ultimately, she was placed on probation with this condition here that has some restriction on Second Amendment rights, even if it doesn't include an unloaded shotgun. It does include other types of Second Amendment rights. And she wasn't afforded the opportunity to be heard beforehand, which is a violation of due process rights, and that makes this particular condition of probation, without speaking to all the other conditions, this particular condition was unconstitutional. And because it was imposed in an unconstitutional fashion, it should not be considered as a legal basis or a legal disability for purposes of this criminal charge. And we have issues as to why, and this could go on for a long time if I were to get into them, I'm not. But we obviously have issues with these type of conditions and how they're routinely imposed in cases like Mrs. Astacio's, involving restriction on somebody's rights to obtain or possess weapons that would otherwise be lawful to them. And these are routinely imposed in cases like Mrs. Astacio's, which is a misdemeanor first-time DWI, even though there's no clear correlation to weapon possession whatsoever. And so we challenge the constitutionality of the condition itself in addition to the statute. And so there's essentially 4 different bases that we, for that. I think it shows a lot of integrity and that he was upfront about what took place in the grand jury and let us address these issues in advance. I think we covered it in the papers for the most part, but I think...
You would agree, if I could interrupt you for a second, and again, I've had a chance.
If the court has any questions or any issues to respond to, I certainly would be happy to do that. Otherwise, I don't have anything else I think I need to add at this point.
Thank you. Mr. Porsche.
Thank you, Your Honor. I guess I'll
You can
use
stay seated if you're more comfortable.
the podium too. To work backwards, Judge, as far as the instructions in the grand jury, the legal instructions, the Court of Appeals says we only have to actually read the definition of the penal law statute. I went way beyond that. I gave the criminal jury instructions from the court system to the grand jurors. As far as the original, the curative instructions to the grand jurors, again, I went way beyond what I normally do in a grand jury case. I asked them several questions. Everyone there assured me they could be fair and impartial, and they would decide this case without bias or prejudice, and they would decide it only on the evidence that comes before them and the legal instructions that I give them. We have to presume they were counsel's argument that this gun restriction was imposed on his client unfairly or illegally or unconstitutionally. She could have taken an appeal and argued that issue to an appeals court. She did not do that. She's waived that issue that it's unconstitutional as far as her Second Amendment rights have been infringed. Back to the basic argument, Judge. The statute says basically you can't own a shotgun if you have a prior conviction or some other disability. In this case, it's some other disability is what they're dealing with, but again, you got to look at what's the other disability prior conviction. We submit that condition number 9 is, quote, some other disability. It's kind of related to a prior conviction. The real issue in this case, Judge, is whether the shotgun, the unloaded shotgun, is a dangerous weapon. The dangerous weapon, I couldn't find any definition anywhere in the penal law. And I don't think it's appropriate to define some other term in the penal law and use that other term to define what dangerous weapon means. I submit that plain meaning is appropriate, or common sense meaning. And what's a common sense meaning of dangerous weapon? That it's a shotgun, whether it's loaded or unloaded. holding that brand new shotgun and be able to, and we proved it was operable with the lab results. That's a dangerous weapon. That can be used to hurt people. We submit the council's argument that we should interpret the term dangerous instrument, which is in the penal law. I submit that's not appropriate. If the sentencing court had really intended to mean only loaded shotguns, it would have used the penal law term deadly weapon, and that's defined in the penal law as any loaded weapon. That would be any loaded shotgun, rifle, pistol. They could have used that term if they meant only loaded weapons. I don't think Judge Aronson intended only loaded weapons. I think he intended loaded and unloaded weapons. Under the defendant's interpretation of that condition number 9, if you agree with what he's arguing, the defendant would be prohibited from possessing pepper spray, a loaded shotgun, or an unloaded pistol. But she could possess a dozen unloaded shotguns with thousands of rounds of ammunition. Reading that condition number 9, that's not what that allows. Under a common sense meaning or a plain reading of that condition number 9. As far as the attempt, she is charged with attempted possession, or I'm sorry, attempted criminal purchase. She did come dangerously close here. We don't have to prove that she actually got that gun, was just about to walk out the door with it to her car. She went in 2 different Dick's Sporting Goods stores. She tried to buy it at the first one. We didn't indict her on that one, but at the second one in Henrietta, she actually had the gun in her hand, and she told the sales clerk, "I want that one. I want to buy that one." She held the gun. "Yep, I'll take it." She actually gave her driver's license to the store clerk, which is the first step in buying a gun, is handing over your driver's license. And at some point thereafter, that store clerk determined that he wasn't going to sell it based on internal policy, which they have discretion not to do. And it didn't stop there. She wanted to buy that gun. And then a second employee was there at the counter and wanted an explanation why, and he couldn't satisfy her, and then she wanted to talk to a manager. So they called a manager over, and she argued with the manager. She wanted to buy that gun. We submit, Judge, that satisfies the attempt element. And lastly, Judge, if you do find anything wrong in the grand jury proceeding, we would ask permission to represent the case. Thank you.
Thank you. Anything in rebuttal, Mr.
2 very brief points, Judge. First of all, the conditions would not, under any circumstance, prohibit the possession of an unloaded pistol. Sorry. They would not have prohibited the use of an unloaded pistol because the conditions specifically included the term firearm, so that a pistol would be prohibited no matter whether it was loaded or unloaded. And obviously the terms could have included the condition shotgun. It would have had the same effect of prohibited a shotgun even in an unloaded condition, but there's a distinguishable factor there. So Mr. Porsche, maybe he misspoke, but he said, well, they would have included an unloaded pistol. Under the defendant's interpretation, that's not the case. The term firearm specifically precludes that in the same way the term shotgun would have precluded the possession of an unloaded shotgun if it had been included in the term. That's not the case. And then the other issue is Mr. Porsche was talking about the moments after they said they were denying her, and how she said, "I still would like to buy that gun." And I would note that during that period of time, she repeatedly asked, "Why am I being denied?" That speaks to the mens rea element. So the statute, in terms of the mens rea, isn't know or should have known, which is sometimes the mens rea in statutes like the AUO statute, which we cited. It's did knowingly attempt or knowingly purchase the gun being aware of the disability. And all evidence in this case suggests that even as she was placed under arrest, she still wasn't clear on why she was being placed under arrest or why she had been prohibited from purchasing the unloaded shotgun. So I would say, yes, there was some additional conversation, but I think the conversation actually cuts in our favor in terms of it supports the insufficiency in regard to the mens rea.
Thank you.
Thank you, Judge.
I will note that these motion papers are among the most voluminous I've ever received on any felony case in my career, and that includes dealing with homicides. Both counsel for Mrs. Astacio and the people are to be complimented. I'm going to reserve. I will have a written decision forthcoming in the immediate future, and I will address everything that was raised in your motion papers, Mr. Philby. Anything else, counsel?
I guess just on that issue, are we scheduling any other court dates, or are we just?
Depends on my ruling. You know what I'm saying?
Yes, absolutely.
And again, I'm going to digest your argument, and again, I'm also going to review the grand jury minutes another time.
Thank you, Your Honor.
Okay, anything else?
No, Your Honor.
Very good, thank you. And again, thanks everybody for their time and efforts. I'm standing recess, folks.
Anything you want to share, Mrs. Astacio, about this? No, thanks.
We'll speak in